Georgia just killed its biggest election case, and here's why that decision may have actually saved the justice system. After years of headlines, accusations, indictments, and national political chaos, the Georgia election interference case is gone, dismissed just like that. Remember, this case began with allegations that Donald Trump and several allies illegally attempted to overturn Georgia's 2020 election result. At the center was that now famous phone call, Trump telling Secretary of State Brad Raffensperger to, quote, find 11,780 votes. Prosecutors said it was criminal pressure. Trump responded that he truly believed votes were miscounted. Then came the sweeping RICO indictment crafted by Fulton County District Attorney Fani Willis. 19 defendants, broad conspiracy theories, and allegations that fake electors, data breaches, and legal maneuvering added up to a coordinated plot. But the case didn't even survive the controversy surrounding Fani Willis herself. A judge stepped in and said she could stay on the case, but only if her special prosecutor resigned. That prosecutor was Nathan Wade, a man she'd been romantically involved with. When a new prosecutor finally reviewed the file, the decision was quick. The remaining charges were dropped. The new prosecutor concluded that the evidence was thin, the legal theories overreached, and the state could not ethically push this case any further. This is not about politics. This is whether the prosecution served justice or serve something else. Prosecutors originally believed the evidence showed a coordinated effort to overturn Georgia's election results. They argued several points, including Trump's call was a criminal solicitation, the fake electors plot was part of a criminal conspiracy, pressure on local officials crossed the line into illegality, and Georgia's RICO law fits broad schemes, including political ones. They saw this as a historic case, a former president and allies allegedly using machinery of politics to alter an election. In their view, this was exactly what RICO was designed for. Powerful actors coordinating in secret to break the law. From the perspective of the original prosecutor and her supporters, dropping the case lets misconduct go unanswered. Defense teams argued something completely different. The defense argued that Trump truly and actually believed the election was mishandled. And belief, even if wrong, is not a crime. Second, they put forth that the Raffensperger call was a negotiation, not a shakedown. Additionally, fake electors were actually legal contingency slates used by other campaigns in past contested elections. Further, they argued that going forward with the creative legal strategy wasn't a crime. It was an attempt to set a new election law precedent. RICO was actually being weaponized to turn political disagreements into felony. Additionally, the Willis controversy proved the case was tainted even from the start. Put simply, the defense said this case was not criminal law. It was political theater. Point one, the evidence was never clean. The evidence in this case was messy, confusing, political. The prosecutors overreached with RICO. If a jury trial would turn into a political war zone with unclear evidence, dismissal in this case was not weakness, it's discipline. Point two, the DA's own misconduct damaged this case. Fani Willis's romantic controversy destroyed credibility. You cannot run the biggest election prosecution in state history with compromised leadership. When the prosecution has a conflict, everything they touch becomes suspect. Public trust collapses, and so does the case. Point three, criminal court is not a political battlefield. You cannot criminalize every controversial political and creative legal strategy, even those without precedent. If the government starts treating political and legal strategy as a conspiracy, No campaign in America will ever be safe. This case blurred the line between political and criminal conduct. And when that line disappears, justice disappears with it. To sustain a RICO case, prosecutors must show, number one, an enterprise. Number two, a pattern. Number three, underlying crimes. But political acts, calls, pressure, and legal theories present a weak foundation. The statutes in this case do not exist to punish political chaos. They exist to punish criminal organizations. I agree with the dismissal in this case, not because anyone is innocent and not because misconduct didn't happen, but because this case should have never been brought in this form. If the state actually believed its evidence was strong, it should have followed the appeals process, cleaned up its own conflict issues, and proven its case to a jury in court. Instead, from the very beginning, it launched a massive political prosecution built on shaky legal theories, then collapsed under its own weight. In America, we do not use criminal courtrooms to fight political battles, and for these reasons, the dismissal was not a failure. It was a correction. Thanks for watching. If you found this breakdown helpful, please subscribe and hit the like button. It really helps grow the channel. And for deeper coverage, visit crimesdigest.com. And always remember, the truth matters, and so does reasonable doubt.